proceed.
Noted.
Recording has now started.
All right. All right. Is everyone seeing my screen?
Yes, Miss Vera.
All right. Good afternoon, everyone, or good evening. Uh, Today we're going to look at 2017 specimen paper. I have other years, however, to get it in soft copy, I wasn't able to do so. But nevertheless, we're going to go on and see what we can do. For me, for those who are on here who knows how I teach, I love to interact with my students. I don't like when I'm the only one that's talking. So I am hoping that, Orain, through you, they'll be able to talk, respond, just by raising their hands. And of course, Orain, you can allow them to speak. All right. Now, of course, we know that the exam is 2.5 hours, 2 hours, 45 minutes. And you will not be getting options. So even though you have this specimen paper and other past papers, you will not be getting options. It was just 2018, basically, that they decided that there will no longer be any options for law. So you get 3 compulsory questions. All right. So 1 for module 1, 1 for module 2, and 1 for module 3. Now, CXC would have sent out the topics that they will be having the exam on. And so you can use those topics to study for paper 2. Of course, it is not recommended that you just study those topics because, of course, the multiple choice is where you will be questioned on each module and you don't know which ones will come. All right, so let's get into it. Now for module 1, it's Caribbean legal systems, and there's 1 question, but of course there are short answers. They're in short answer questions. All right. Okay, now let's look at question 1. And this question is looking at the jury system. Now, for those of you may not have reached there as yet, or you may have, but it's quite simple. For me, I prefer an extensive explanation. CAPE, however, does not require that extensive explanation in some areas. All right, so that's a good thing. All right, So number one, during jury selection, the prosecutor learns the following about the jurors. Barney has spent 5 years in prison. Sandy, a housewife, applies for exemption because she has the flu. 2 days in the trial, Justice King learns of the recent divorce between Karen, a juror, and Anne, the defendant. Outline the reason why Justice King could dismiss Karen as a juror. Now, there are some instances in which a juror is disqualified from serving on the jury. Can anyone give me some reasons? Orin, if anyone is raising their hand, can you please allow them?
Yes, they're free to speak.
Didn't hear that. Go again.
They are free to speak.
All right.
Krishan Nelson said conflict of interest.
Conflict of interest. Krishan, what does that mean? Krishan, are you able to unmute your mic?
Basically just mean that there is some attachment between, for example, the juror and the defendant,
All right. Yes.
or the facts of the case or something like that.
Right. Right. So the conflict of interest there would be where Sandy, not Sandy, Karen was just recently divorced from the defendant, Anne. So that is one of the ways or one of the reasons why a juror can be dismissed. All right, so it asks, that's for 2 marks. So once you highlight based on the fact that there was a personal relationship, they were just divorced, so bias could come in, hence the conflict of interest. Once you give that response for A, you'd have gotten your 2 marks. All right. Now let's look at B. Explain whether the following persons could be disqualified from serving on the jury in a named Commonwealth Caribbean state. Do you realize that the question does not only speak to if they could be disqualified, but it is asking for a named Commonwealth Caribbean state? Which Caribbean states would you highlight? And I'm not sure, well, I'm assuming all of us on here are from Jamaica. So
yes,
we're gonna use Jamaica. Right. All right. All right. So what about Barney?
Afternoon, Miss. Barney would be disqualified. He could be disqualified because he would have been convicted and sentenced to imprisonment for a period in excess of over 6 months.
Right. So Barney is a convict. Hence, he cannot serve on the jury. All right. And of course, you would highlight the whole aspect of once you're imprisoned and you would have served your 6 months, or more than 6 months, you're convicted of an indictable offense. When we say indictable offense, what does that mean? Do we know what an indictable offense is? Anyone wants to try that? All right. Well, your indictable offense just simply means you can serve time in prison. All right. Now, for Sandy, what about Sandy? Anyone? Anybody would want to answer for Sandy? Sandy is sick. She has applied for leave of absence on the jury because she has the flu. So what would we say for Sandy? Prashant?
Oh, sorry. I was saying I don't think she could be disqualified because she has a valid reason with the sickness or with having flu or whatever.
And when they say disqualified, it just means you will not be able to serve on the jury. So let's say, for example, it's the flu, it's the bad flu. She isn't eating, she's weak, she is having a fever, all of those stuff. She's very contagious, really. It's the bad flu. Then yes, she could be disqualified from serving because of such a serious medical condition. So if it's just a little sniffles that she was having, she wouldn't be disqualified. All right. But seeing that she has the flu, if it is that type of flu that you definitely cannot be around people, then definitely she would be disqualified. Now, in some countries, of course, it's dependent on the judge's discretion. If the judge realizes that this person clearly would not be able to function properly throughout the period, throughout the process, then they would disqualify. Right? They would no longer be able to serve on the jury. COVID, clearly, seeing that we are having COVID now, if someone is required to serve on the jury and they have COVID, clearly that would be a serious medical condition, hence they would be disqualified. Are we following so far? Are we getting it so far?
Yes, I'm understanding.
All right, good. All right, so and of course, we now need to look at number 2 of B. Outline 2 disadvantages of trial by jury.
Miss, I think one could be it could take a long time to reach a decision.
Yes, especially in Jamaica.
And there's no obligation to make a decision based on facts.
Good. Any other disadvantage? How about, and I'm asking, and let's talk about our Jamaican system. Currently, a juror is selected, or members of the jury, they're selected from the electorate list. We call it voice. So once you have a voter's ID, you're in the system, and so they randomly select you. Is that sufficient in the selection of a member of the jury or the jury? Process of vetting these persons, the empaneling of the jury and all of that. Do you think that would be sufficient? And let's take, for example, a very popular case that we can jump to would be the Vibes Cartel case, right? And of course, a member of the jury tried to bribe the foreman of the jury. Now, we would want to think that jury was properly vetted, or members of the jury, they were properly vetted based on your random selection. Would that be a disadvantage of a trial by jury? With the whole aspect of the selection of each member. Because remember now, when you have a voter's ID, we don't know if you're a criminal, we don't know if you are a learned person. And when we say a learned person, we mean someone who actually would have knowledge of whatever the matter is that's before the court. We don't have knowledge of any of that. We just select members from the voters list, and then they're empaneled. So that would be an disadvantage. Would that be a disadvantage? Does anyone think so?
Yes, yes.
Definitely. Of course, you not having a knowledge of certain things. So say, for example, we're looking at some terms now, right? Like your mens rea. Let's say the attorney says the mens rea of murder, Your Honor, my defendant does not have, my client does not have the requisite mens rea, or he does not have, there was no transferring of malice, or, you know, we use other terms, right? Me being a regular man, a reasonable man, I wouldn't have a clue what that means. What does mens rea mean? What does actus reus mean? I wouldn't have a clue. So that could possibly be a disadvantage, seeing that I'm just there sitting down wondering, what is mens rea? What is actus reus? I don't know what that is. How am I going to make a decision when I don't have a clue about certain things? Even though we know in truth and in fact, the jury should make a decision based on facts presented. But sometimes that can be a disadvantage as well. All right? So any two would give you 4 marks. All right, so let us look at the big one now, 15 marks. Usually students would ask me, Miss, how many pages can I write or should I write? I would get the 15 marks. That's not the case. It's not about the amount of pages. It's about the information that you have. All right? So they're saying assess for benefits of a trial by jury against a trial by a single judge. Anyone wants to attempt that or start that? All right, let me see if I can find a name. I love to pick on students. Ricardo. Mr. Dawkins.
Yes, miss.
Would you want to start? Assess for benefits of a trial by jury against a trial by a single judge. What does the word assess mean there, guys? Because remember now, you have to understand what they're asking you for. So you're supposed to assess the benefits of a trial by jury as against a trial by a single judge.
Does it mean to state and analyze?
You state, you analyze, you explain, you compare. So you're making a comparison. Trial by jury is beneficial because so and so and so, as opposed to a trial by a single judge, which is so and so and so, right? Now let's start. If you were talking about a trial by jury, which benefit can we highlight?
The benefits of varied opinion.
The benefits of
Varied opinion.
varied opinions. Because every man, or terms, the reasonable man, each of these persons are considered reasonable man or reasonable men because one, they are in their right mind. Two, they would look at the facts and they would probably say, yes, if I were going through this situation, I would probably have done this or whatever, right? So varied, go again for me, honey.
The benefits of varied opinions.
The benefits of varied opinion, as opposed to what?
One mind.
Right. So a judge may be biased due to the fact that he's the only person there listening to facts that he, of course, would have knowledge of the different terms and jargons and all of that, compared to your varied opinions. Persons will be thinking, I wonder if probably he did this because, no, but clearly he does not have the mens rea, or he didn't have the mens rea while he was doing it. He didn't have the intention. Oh yes, probably, oh yes. You understand? So that's one of the benefits. Varied opinions as opposed to a single judge making a decision.
Good evening, Miss. Good evening, everybody. I was going to say more. It allows room for more objection, but it's kind of similar to the varied opinions.
Right. So they're more objective. Anything else? All right. So remember, when we say somebody, when we're looking at criminal law, the person would have committed a crime against the state. The people would represent the state. The jury would be representing the people of the country, because that person would have committed a crime against these people, right? So it is much more fair in having citizens who would be experiencing the same situations, who would be going through the same day-to-day life, and would have known and understand and realize that, you know, possibly anything could happen. So the jury, by our trial by jury, is where you have a lot of persons who, you know, would probably be more objective. So they bring the feeling of, I am a part of society. I would possibly understand why you did what you did, or maybe not. So that's one of the things. The citizens, I feel much more safer with the citizens deciding my fate as
Mr.
opposed
Davis,
to the one man. Go ahead, honey.
Francis Miller said that chances of equity or equality is higher with a jury as opposed to the decision of a single judge.
Correct. Fairness. That's another one. So we know that equity is fairness. So would a judge be fair as opposed to you having a group of people deciding your fate? They would be fair because they now will look at it from different angles as opposed to a one man. He may not be able to because it may be overwhelming. All right, so fairness and that whole aspect of if none is fair, and that is why I'm sure you guys would have watched How to Get Away with Murder and all of those movies that deals with the law. And in the empaneling of the jury, you'll hear if it's a black man who committed the murder, you know, the attorneys would want, let's say, if it's a black man who killed a white woman or a white man, they would want less women on the jury or less white women, or, you know, they mix it up because they want to ensure that these persons are fair. All right. Now, of course, the judge, being that he is an expert, he wouldn't be recognized so much as being fair, seeing that he's learned compared to a group of people who would be fair. Equity. Anything else? It's worth 15 marks. And we should explain 4 benefits. How many benefits have we gone? All right, another one is looking at how bias the judge would be, seeing that he's a single individual. And of course, it would still be basically the same as what the young lady would have highlighted. But of course, it removes the possibility of bias when you have multiple persons having different, you know, convictions. So there's no prejudice. That is why if you have 9 persons or 12 persons on the jury, you have probably 3 saying not guilty, 6. And of course, it has to be a unanimous vote. Of course, if it's tied, and we know it goes into all of those things. But you find that there's less bias when you have multiple persons deciding a fate of an individual compared to a judge who is one individual and who can have biases. All right, so are we clear on those? Talk to me, guys. Feel like I'm the only one here.
Miss,
All right.
we did 3 benefits.
Didn't hear that.
We did 3, not 4.
Oh,
See? Because I was talking, I'm not realizing. All right, so we said bias.
Ms. Ashari Allen said in the chat that another benefit could be that ordinary persons may be more aware of the realities in the society and are able to use their collective experiences to return a true verdict.
Correct. Correct. All right. So and I think I had said something like that because they're going through the same situation, they know what's happening on the ground, as opposed to a judge who probably we're not going to say who is out of touch with what, but he may not be around these experiences or these happenings as much as our ordinary citizens.
Mr. also stated that we could also note that they are able to use their common sense to determine the guilt or innocence of a person.
Common sense, yes, based on facts. They definitely use their common sense. While the judge, and of course, the judge is going to use his knowledge, his background in the law to make a decision, as opposed to him being a regular man using his common sense. Correct. Anything else, guys? We can move on now. Let me know. All right. So that would be module 1. Caribbean legal systems. What I should also add before we move on is that all 3 modules, you can either get fact patterns or essays. They usually mix your fact pattern and your essays. Sometimes, yes, they will send you fact patterns and straight fact patterns for all 3 modules. Sometimes, I've never seen an exam where you have straight essays for each module. But be prepared for an essay. All right. So legal systems, you have some topics that are essay related, while some are just fact pattern related. And when I say fact pattern, do you guys know what I mean by when I say fact pattern? Anyone wants to highlight if they know? Anyone?
They give you a scenario of what's going to take
Nobody's
place.
responding, Oren?
Hello?
Francine Green. Oh, Ashley Johnson, go ahead.
I'm sorry for not raising my hand. Anyways,
all right, so your fact pattern
okay,
is where you're given a set of facts. For example, with the Barney and Sandy. And then they ask you to explain something or to they give you a scenario, right? Go ahead, Ashley.
Oh, Miss, I think your internet is delayed, you know.
okay, everybody hearing me now?
Go ahead, hon.
Yes, as I was saying, sorry I'm for not raising my hand. And when you said fact checking,
Rain?
I like to think that means that they give you a scenario of something.
Rain.
A scenario that takes place, and then you'd have to explain it. So you'd have to break it down, and then they have the ABC to it.
Are you guys hearing me?
Guys, please give us a moment as we...
Can someone let me know if they're hearing me? I'm not hearing anyone. Yeah, I'm sorry about that. Yes, honey, hearing you now.
Guys, she will be back in a minute.
Sorry about that, guys. I had to use another device. Is everyone hearing me?
Yes, we're hearing, miss.
All right, so let me try and share my screen. All right, let me know if you're seeing.
We are seeing, miss.
All right. So the young lady that came on, I was hearing you. You were saying we're presented with a scenario, and then we are required to give a response. We're required to answer questions that are asked. And I said yes. So you're given a set of facts. And then, of course, you're required to answer. Now, in answering the fact pattern, you are required to answer in something called an IRAC form. And it's an acronym for issue, which is the I, R for the rule, A for the application, and C for the conclusion, IRAC. Now, they may give you, let's say, I think possibly there is going to be one in criminal law. So I'll be able to indicate to you or show or tell you how to respond. But you highlight the issue based on the facts that you're given. You discuss or you list the rules that are required for the set of facts. You apply the rules to the facts and then you conclude. And I know a lot of students, they love to jump ahead and conclude before they even do that. But you must always follow the steps. All right. So let us move on to, and I was going to also highlight some of the topics, possible topics that you can get in the exam. And I'm not looking at those 5 topics now because I don't have them on hand right now. But possible topics that you can get as essay. With an essay, you do a regular essay. It's just that it is gonna be legal based. You must have an introductory paragraph, you must have your body, and you must have your conclusion. However, you're gonna speak from a legal perspective. So, possible essay questions, you have the nature of law. So they can ask you about the theories, they can ask you about religion and morality, they can ask you about sources of law, they can ask you about the ombudsman, and of course, the ombudsman would be more than likely a fact pattern. ADR would be fact pattern, classification of law, hierarchy of the courts. So usually most of the topics in U1 would be fact pattern. All right, so let's move on to module 2. Four marks. Explain briefly 2 features of the doctrine of separation. Anyone wants to attempt that? And it did say briefly. So 2 marks for one and the next 2. Go ahead.
Zidane.
Good afternoon. I'll just like to attempt how I think it would be addressed. So I would make mention of it said briefly, so I'd make mention of the checks and balances. I'd also state the 3 different branches which powers are separated into, which would be the legislative body, the executive body, and the judicial body. And
Right. Go
briefly
ahead.
explain the checks and balances and what they are for, basically.
And when you say the checks and balances, what do we mean?
Meaning that no one branch has too much authority or power. So
Good.
to minimize or to thwart the ability for abuse of power, each branch would ensure that the other is in order.
Right. And also one of the other features, well, let me ask, anyone else? Anybody else who wants to give me a feature or features?
Oh, after you have spoken, please lower your hand.
All right. So we can also highlight the whole aspect of the independence of the judiciary. Very, very, very important. Because while we highlight the different organs, the three organs of the state, we must highlight how important the independence of the jury is. All right, so that's a major, major aspect of separation of powers, or a major feature of a separation of powers. Anything else?
Ashley Johnson, your mic is open. Go ahead.
Ashley?
Miss Selena Evans is asking for you to.
Please.
Go ahead, Selena.
But she's asking for you to repeat.
Okay, right. I'm sorry, I didn't hear you clearly. Right, so the young man had highlighted the different organs of state, highlighting the different organs of state, saying that you have your executive, your legislature, and your judiciary. I was saying that when you highlight that you have those three organs of state, another feature that you can speak to and should speak to is the independence of the judiciary. And when we say the independence of the judiciary, we mean that while a legislator and your executive, they make the laws and enforce the laws, or not necessarily enforce, but administer, the executive would be the administrators of the law and to ensure that laws are being made for the right reason. Your judiciary is independent because they interpret the law. And so you can't have a legislator being on the judiciary. That is where you're going to have conflict of interest and there is a bias. All right? So we need to highlight the independence of the judiciary. Anything else, guys? Any other feature? There was another aspect that the young man had said, that balances. So basically what they're saying is that the executive
Ms. Zidane Skeen is saying the history of it.
Didn't hear that.
Malika
What?
Williams. Zidane Skeen is saying the history of it. And Malika Williams is saying ultravirus. I am not even aware of them.
Well, even if you're going to highlight ultravirus, that would still be a totally different topic as it relates to your separation of powers. I would more speak to the rule of law with the whole aspect of nobody's above the law, hence your separation of your powers. But those would be two different topics that wouldn't necessarily be a feature of your separation of powers. The young man had said the history of your separation of powers.
Mr. I'm not sure what he meant. He just said the history
Yes,
of
miss.
it.
I don't know if it would be too much information. Sorry to interrupt, but I would
Fine.
probably speak on who coined it, just for introductory purposes, and the reason. So I'd speak to Baron de Montesquieu, coining it for, to go against abuse of power, basically, and then I get into it.
All right, so that would be too much.
Okay.
But it's good to know the history, because this topic is a definite essay topic. So when you're having your separation of powers, say separation of powers was on the list essay topic, because this is thorough. You know, you'd have to talk about Piaget, you would have to talk about Montesquieu and Aristotle and all of those people. So it's good to know the history so that you'd be able to write an essay on it. So the history would be too much. Just the main features of your separation of powers, the doctrine, would be your organs of state, the checks and balances, the independence of the judiciary. And of course, the protection of the judiciary, because we know that in the Constitution, judges are protected, the judiciary is protected. You cannot fire a judge as you would want to, stuff like that. All right. All right. Now, for this question B, when you do the Constitution, which is a source of law, you'd find that the different chapters speaks to different things, right? And so one of the chapter would speak to the judiciary, the executive, parliament, cabinet, etc., right? So describe 3 methods in which the Constitution of a named Commonwealth Caribbean country enshrines the separation of powers doctrine. Let's go. Anyone wants to start? All right, hold on, guys. I'm going to pick a name. Amelia. Miss Cole? Nobody wants to try? Amelia? Is it Dahlia or Dahlia? Everybody is afraid? All right, so let's go. So how would they ensure that your separation of powers doctrine is enshrined in the Constitution? 1, I just highlighted that the Constitution would speak to the judiciary. It has a chapter which speaks to the judiciary. So how independent it is, how judges should be assigned, hired, how your different judges are to be selected, That speaks to your separation of powers. It also talks about how a judge should be removed or dismissed, and it's not that easy to do so. All right? So it takes a process of highlighting how separation of powers or the doctrine of separation of powers works. Another one, of course, and once you understand what separation of powers is, you'd realize that when you talk about separation of powers, if you don't talk about the independence of the judiciary, then you're not highlighting separation of powers. All right, guys? Please note that. Because yes, you might talk about your three organs of the state, but how separation of powers comes in is where the judiciary is so independent that if the executive or the legislator makes a decision, because remember the executive and the legislator, they are in parliament, so they have to work together. So sometimes biases will come in, but how independent, and because the judiciary is independent, then the judiciary would be able to make a decision as it relates to that. And one thing that comes to mind, which explains how independent the judiciary is and how separation of powers works, is the NIDS bill. I'm sure you guys would have heard about it, where the Court of Appeal made a decision saying, hey, this bill is the amount of sections in which it would contradict the Constitution and contradict what it says about the fundamental rights of the individuals. Too much of it contradicts the Constitution, so it is null and void. You have to start all over. That in itself explains separation of powers and how independent the judiciary is. All right? Because you would have realized that two other organs would have worked together in order to bring about the NIDS bill, and that would be a legislator and your executive. Now, because they are working together, your biases, hence the independence of the judiciary, is where the essence of separation of powers comes in. I hope we're following so far. Let me know, guys, please. So are we following so far?
Diamond Campbell, go ahead.
Go ahead, Diamond.
Asking, it's like, you know, the Jamaican Constitution for Section 48 says that Parliament has the authority to make law in peace, order, and good governance. Mr. Adding to what you're saying, Miss, the independence of the judiciary, Miss, it acts on that to ensure that Parliament makes laws in peace, order, and good governance.
Correct. Correct. So whatever law that is made cannot contravene anything that the Constitution says. And mind you, some of the laws that they're going to make, not all of them will be null and void. Probably Section 1, subsection 2, paragraph A, paragraph B could possibly go against the Constitution, and so they have to remove that. So not all, the whole law in essence may be null and void. Whatever section or sections within those laws that are made that contravenes, that contradicts the Constitution, especially our fundamentals of rights, the three there, then they would have to change it. And the only way that you will be able to see how clear these laws are or contradictory is when you have the judiciary making such a decision. The judiciary is free to make a decision. So we're clear on that, guys? All right, so let's move on. passes the Child Court Act, the judges of the child court are to have the same powers of a high court judge. In accordance with section 104 of the Constitution, high court judges are appointed by the Judicial Legal Services Commission. Section 15 of the Child Court Act provides that judges of the child court are to be appointed by the Minister of Justice. Justice Brown, a child court judge who is appointed by the Minister of Justice, convicts Jane of an offense. With reference to two decided cases or examples, advise Jane whether Section 15 of the Child Court Act is unconstitutional. This is a fact pattern. All right. Now, how do we go about doing or answering our fact patterns? We have our issue, our rule, our application, and our conclusion. Can anyone highlight what the issue is?
Miss it ultraviolates the Constitution. Section 15 of the Child Court Act is against what the Constitution said.
Are you stating it or are you asking if it is?
Stating, miss.
That's the thing. So when you're stating an issue, you basically would have concluded. So looking at dealing with it from an IRAC perspective, it's a question that you ask for the issue. All right. So whether or not, we usually use the word use whether or not. Section 15, of course, of the Child Court Act, if it violates or contradicts what the Constitution is saying as it relates to your, let's say, what you said ultra vires?
Yes, yes.
Right. Or separation of powers. So are we clear on that, guys? Are we following? So whether or not. All right, so we then would now move to the rule or the law. Right off the facts there. What would you guys look at? If we're talking about separation of powers, which cases comes to mind?
Miss Hines v. the Queen.
Right,
Yeah,
Hines v. R. And what does that say? And here now, guys, we're not expecting you to give the facts of the cases. We don't want the facts of the cases. We just want the principle in the case. All right, guys. So what's the principle?
Miss, is it that the principle of separation of power was implicit in the Constitution and Parliament had no power to transfer from Judiciary to the Review Board?
Yes. So you have Hines versus R and you state that. Okay? Any other case?
Miss, you also have the
Yes.
Julian Robinson versus the Attorney General as it relates to the NIDS case.
The NIDS case, yes. I was waiting for someone to say that because that ruling would have come out, so it would have been gazetted. So it is a case that you can use. It's a reported case. Any other?
Miss, what about Adrian Nation and Karim versus the DPP?
And that's the Bails Act. That case is about the Bails Act. Yes, we can use that. Anybody else? So we can also use the Estefan case. Do you remember that case? Do you remember that case, guys?
No, Miss, can you give a bit clarity to that?
All right. So your Estefan and your controller case, this is where they basically said that they didn't have any constitutional authority to do anything as it relates to customs. They weren't able to clear persons from customs. And let me, I'm sorry, we don't have, I have books in soft copy, but I wouldn't be able to go to it right now. So your Estefan case, the Heinz and R, the Adrian Nation, so basically what they were highlighting was that these bodies, Parliament, did not have the right, not have the authority to make such a decision. Parliament cannot interpret the law. Only the judiciary can. So based on the facts that you're given now, you would have to apply these cases or apply the principles to the facts. So let's apply it, guys. Anybody want to attempt to apply it? Now, please also remember, for your fact pattern, any two cases, just remember two cases. You don't have to remember all of them. Remember two cases for each topic. All right, once you do that, then it will work in your favor. And of course, for your essay topics, remember more than two, because sometimes they say at least, or they're not just asking you for one case. So let's apply the facts now to the law, or the law to the facts. Can someone help with that? Parliament passes the Child Court Act. The judges of the Child Court are to have the same powers of the High Court judge. In accordance with Section 104 of the Constitution, High Court judges are appointed by Judicial Legal Services Commission. Section 15 of the Child Court Act provides that judges of the Child Court are to be appointed by the Minister of Justice. Justice Brown, a child court judge who is appointed by the Minister of Justice, convicts Jane of an offense. With reference to two decided cases or examples, advise Jane whether Section 15 of the Child Court Act is unconstitutional. Let's go. Come, people, let's apply it. So let's talk about Heinz and R. According to Heinz and R, what happened? The principle. Nobody wants to try it? All right. So the Constitution speaks to the fact that only the Judicial Legal Services Commission can appoint a High Court judge. So therefore, with Parliament stating in the Act that a minister can appoint the judge, they would have acted ultra vires, because they cannot. The Constitution does not allow Parliament to make such a decision. It is the Judiciary or the Legal Services Commission that should do that. The Constitution clearly states that. And so therefore, that judge would not be able to make such a decision in convicting Jane because he was not properly appointed. So Section 15 of the Act would be unconstitutional because the Constitution clearly stated that the Judicial Legal Services Commission can appoint a High Court judge only. Now, Parliament, remember now, we know that the Constitution is the supreme law of the land. Do you remember that? And any law that comes in or contravenes or contradicts the Constitution will be null and void, or to the extent of it. All right, so we can highlight that as well. So therefore, Section 104, not 104, Section 15, sorry, would be unconstitutional because a minister cannot appoint a High Court judge when the Constitution says the High Court judges must be appointed by the Judicial Legal Services Commission. In concluding, the Child Court Act, Section 15, is unconstitutional, and so the judge cannot convict Jane of an offense. Are we following? Talk to me, guys. Orain, am I still on?
Yes, miss, you are here. I am hearing you.
Are we following? Do we understand how we came to that conclusion? How we came to that Krishan, Francine, Philip?
Yes, miss.
Yes, miss.
Okay, good, Zidane. Diamond, which bill are you asking about? Is it the NIDS bill?
Yes, miss, I got it.
All right, honey, all right. All right, so are we clear on that? So remember, you have to issue your IRAC. You have to use your IRAC. Follow your IRAC. You can't go wrong. Because sometimes I notice that students, they jump to the conclusion first. You can't conclude when you have not. Remember, you know, you're a client. Therefore, you cannot conclude until you would have given them the information step by step. So you have your issue. What is the issue that Jane possibly is facing? Whether or not there's a contradiction based on the Constitution and its separation of powers principle. You go into your rules. What are the rules? We're simply stating the laws that would apply to your issue. Application, you simply apply your law to the facts given, and then you conclude. All right. Now, we can then look at Module 3, Criminal Law, and this tends to be very exciting. I think this is the longest, most exciting module. Define the term murder. 2 marks. Simple, simple, simple definition. Let's go. Anyone wants to give me that definition?
Killing with intention.
Killing with intention. So let me ask you a question. With the death sentence on our books, if the court makes a decision to kill the person by hanging, would that be killing with intent? Wouldn't that be killing with intent? Would that be considered a murder? Anyone can answer, anyone can respond.
No, miss, that wouldn't be killing with intent. But however, to answer the question, we could use Coke's definition of murder.
Go ahead.
Miss, there it says that murder is when a man of a sound memory and the age of discretion unlawfully killeth within any country or the realm.
Under the Queen's realm.
Yes.
Sorry, I'm sorry. That it was just coming out. Sorry. Yes. So yes, we can give that definition, that long definition, but we can also give a simple definition. Anyone want to try the simpler version?
Mr. Toy Carter said the unlawful killing of someone. And
right.
So, said murder, unlawful killing of a human being under the
Queen's peace. Yes. Go ahead.
Philip Dixon said the unlawful premeditated killing of one human being by another.
Yo, Philip, I like that. Premeditated. So yeah, it's the unlawful killing of a human being under the Queen's peace. So that simply means if you kill a goat, it's not murder because the goat is not a human being. Right? When you go to UE or UTech, you will even go further. Is killing a fetus murder? No, it's not, based on the definition of murder and based on the definition of a human being. All right. So the unlawful killing of a human being under the Queen's peace, that's fine. Or what the young lady highlighted with saying under the Queen's peace within the realm, within a year. They don't talk about a year and a day anymore. All right, that has been taken off. So once you give that definition for murder, you're good to go. 2 marks. Explain briefly one of the elements of your mens rea for murder. What do we mean by your mens rea for murder?
The guilty state of mind.
Your guilty state of mind. All right. So give me one of those elements now, guys.
Just could you repeat what you said, please?
Give me one of the elements of mens rea for murder. When we're talking about the element of mens rea for murder, what do we mean?
For example,
the young man, go ahead. Then we can have the young lady.
I would say, Miss, one of the elements are recklessness.
For murder?
Miss, also Jamal Hall said premeditation. Sachika Brown said intention.
Right.
I
But
think
the
intent.
question, the young man that says recklessness, would recklessness be for murder? So recklessness would not be for murder. Because remember, in having murder, you have to have intent and nothing but intent to be considered to have the mens rea, the direct intention. So you remember when you were going through intention, mens rea, and you had your different levels of intention. You had your direct, your indirect, and your oblique, and all of that. Do you remember going through that? All right, I'm going to take it, yes. Right. So the young lady was highlighting, she said intent. Yes, you must have direct intention to kill. You must have that intent to kill. Meaning, you intend to kill John, you take steps to kill John, and John is dead because you killed him. Right? Can anyone highlight another element?
Miss malice aforethought.
Well, malice aforethought is basically your intention, yes. But remember, intention. The young man highlighted recklessness. What is recklessness? Anyone wants to take that on?
Miss, I can try. Ashley wants to try.
Sure. Go ahead.
Okay, so Miss, recklessness is when you know the risk that you're about to take and you take it anyway.
You know the risk that you're about to take and you take it anyways. So, for example, I'm driving. I should reach work by 7 o'clock, but it's now like 5 minutes to 7 and I am half an hour away based on the journey that I know. And guess what? I have to go speed and I decide to speed and take the risk. The risk that police may be on the road and they might stop me and give me a ticket, or that possibly I might cause an accident, but I'm taking the risk. Does that speak to enough intention for you to say that the person would have committed a murder?
Scenario.
All right. So I am late for work. Based on the distance that I know, it would take me half an hour to reach work, and it's now 5 minutes to 7, and I should work at 7 o'clock. But in order for me to do it, I can do it, if I speed. So I'm going to anyways. I'm going to do it, take the risk anyways. So I speed. And the risk that I'm taking is that, yeah, police might stop me on the road. I'm not even thinking about an accident. Me on the road. I'm taking the risk anyways. I'm speeding. There's a law against speeding as well. But would that amount to murder? Would that be enough intention to charge the person for murder? Based on the definition.
I don't think so, no.
Right. So recklessness is moving away from that intention. And it's now it's kind of going to another level. So one, you must have direct intention. And that direct intention is, I intend to kill John today. How me I go kill John? And I'm go to his house and I'm going to tie him up. And I'm just being, clear for you guys to see direct intention going along. And I'm going to shoot him. I might just put the gun to his forehead and bam, right? That's direct intention. That speaks to murder. But here's another element of it. Me and John are fight. And I decide that, look here, John, me not strong enough, but today, well, not even kill. Let's remove the word kill. John, me must stab you today. And my intention was to stab him. John no fear left here so without me hurt him. And so that intention to cause such grievous bodily harm. Remember GBH? I'm sure you guys would have gone through that. So you had the intention to element, and the other element is your direction to cause serious, grievous bodily harm, your GBH. Once you had that intention, we talk about serious, grievous bodily harm. We're talking about using a knife to stab the person so many times that that person would not live. Using a car to run over the person to the point that that person definitely would not live. That intention to cause such grievous bodily harm, that is an element. So if you highlight the direct intention, and then of course that intention to cause grievous bodily harm, then you would have gotten the marks. Are we clear about that, guys?
Yes, miss.
All right. Lanicia? All right, let's go on. Let's move on. All right. Identify 2 instances where a person might be found guilty of involuntary manslaughter. Give an example of the case for each instant. What is involuntary manslaughter, guys? Anybody wants to answer that?
Excuse me, Miss?
Yes, go ahead.
This one instance would be a motor vehicle accident.
Right? So involuntary manslaughter is where you don't have the direct intention, but you're negligent. So the young man who highlighted recklessness, recklessness is more manslaughter, all right? So your recklessness and negligence, those would be for involuntary manslaughter. Your voluntary manslaughter would speak to your direct intention. And you said, yes, but you have different types of manslaughter, which is, of course, as we say, manslaughter by gross negligence, manslaughter by recklessness. You have manslaughter by unlawful and dangerous act. The car accident, explain that one for me. Can you give me a scenario?
Miss, you're just driving on the road one day and then you carelessly hit somebody over, but you did not have the intent to cause them harm.
Right. So I wanted you to kind of highlight the manslaughter by unlawful and dangerous act. The person was reckless. Go ahead, honey. Go ahead.
This is my scenario. Same thing, motorcycle. So for example, this truck driver is driving along the road, have load in the back of the truck and so forth, and he's speeding, right? And he's passing a school where you have the pedestrian and the people,
right?
You have the people who cross, the children them and so forth, and it so happened that he lost control of the vehicle, and it just happened just to hit over the man and kill the man and that of the side.
Yeah, right. So the unlawful aspect of it would be what?
Perhaps he's speeding, passing a school.
Right. That says slow down. Children, school, you see the school sign. And clearly, if you did not buy your license, even though we know that literate persons buy their license as well, which is illegal, people. But if you don't buy your license, you know what it means. Slow down. But that person is speeding the same way. So he would have broken the law, which makes it unlawful. And the act was dangerous because he's at a school where you have pedestrian crossing and you see children crossing and you're still speeding. You cause an accident and someone dies. That would be a manslaughter by unlawful and dangerous act.
Miss, and
right?
a popular one would be like texting and driving, miss.
Correct. Now you need to highlight your cases because remember now it says 2 instances and you highlight cases. All right. Now, if you were looking at intention and we went through all of the intention, your different cases where it says infer and you move from infer to find and you all of those cases, you would realize that the case is there to give you some aspects of manslaughter. You're talking about your Woolen, your Nedrick, your Hancock and Shanklin, those cases can give you an example of your unlawful. Hancock and Shanklin would be, they were having a protest and the mine workers and they decided to block the road and they were under and then decided to throw down some big stone and a car was passing under and the stone dropped and it killed, you know, all of those things, right? Another one you have is a manslaughter by negligence. We know what negligence is. You must have a duty of care. You breach that duty of care and that accident. Anybody want to give me cases for that? We have tons of cases. Omission, you'd realize that a lot of these cases speak to your manslaughter by negligence. Anyone?
Miss, could an example be where the mother's dying childbirth due to negligence or they're not being taken care of properly after giving birth?
Right. Any case comes to mind?
Miss, what about RV Pitwood?
RV what?
Pitwood, Miss, it was about the case where the guard forgot.
Right, the hand-driven cart. Was it Pitwood that was at the was it the hand-driven cart or was he the attendant at the gate?
Yes, Miss. That's
where he had right, the contract, yes. Gibbons and Proctor, all of those, your omission cases can be used there for instance because all of these persons had a duty and they breached that duty which caused that death. Adomako, all of those cases, instant. All right, creating a dangerous situation and not doing anything to stop. All of those cases can come under manslaughter by manslaughter by recklessness. You can talk about Maloney, you can talk about Hyam.
Miss R versus G and R.
Tell me what G and R is. Don't remember that case.
So
remember the fact?
It's yes, not clearly. But it's with the house, and he lit the house. I think it was 12 o'clock in the morning. It's an English case. Where he lit the house with the stepmother in there and a child, and they died. And he was aware of a risk, and he took the risk.
Right. Well, we find the GNR, of course. Are we talking about the person? All of those is you just have to see that there's a risk and you take it anyways. All right? Cases. All right, so let us look at C, which is the last one. John is frustrated, and this is a fact pattern again, guys. John is frustrated with his girlfriend, Tina, who constantly nags him. One evening, John beats Tina severely after her usual nagging. Tina dies as a result of the beating. Explain whether John is liable for the death of Tina. In your answer, give one decided case as an example. What defense, if any, may be available to? In your answer, give decided cases as an example. All right, come on now, guys. Iraq, the issue.
Whether or not, is it John? Whether or not John is liable for the murder of Tina.
Good, 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 good. Saying whether or not he is liable for the murder or the death of Tina, we now have to go to the rule. What is the rule, guys? What is the rule? What are we looking at? Come on, people. Explain whether or not he's liable. You need to state why he's liable. We're going to that now. We're going to have to highlight and the actus reus. Which aspect of the mens rea are we talking about?
The intent.
No, ma. We said, let's talk about the actus reus first. The actus reus. Right. So therefore, he had committed the guilty act, right?
Yes, miss.
Right. So he beat her and she died from that beating. What are the mens rea? He was so angry, he couldn't take it anymore. And so he decided to give her a fine beating. Getting that beating, clearly, he must have that intent. He didn't have the intention to kill her, but he had the intention, after couldn't taking the nagging anymore, to cause serious, grievous bodily harm. Not true? So if you can highlight, right, so if you can highlight that, you highlight the actus reus, you highlight the mens rea, but there's another aspect of it that you need to put together. Remember, you can have a guilty mind, but if you don't have the actus reus, you cannot be charged for the act. So therefore, what must coincide?
The actus reus and the mens rea.
The actus reus and the mens rea must coincide. Have a guilty mind along with the act. All right? So you must prove that John must have had mind while committing the actus reus. They must coincide. If they don't coincide, then chances are John will not be charged for murder, because he must have the intention to kill her, or the intention to cause grievous bodily harm. Are we seeing that? And of course, we can look at the case of Maloney. Lamb was the one where in the argument they had was it when they took the drug together? I'm mixing up the facts now.
Miss, when he pointed a revolver at his friend.
Didn't hear that.
Miss, when he pointed the revolver at his friend, Miss R.V. Lamb.
Right. And they didn't even know about the barrel, the amount of bullets in the barrel and all of that. All right. So you use any of those and you explain it, and you would get your 6 marks. No, I'm at C. Yeah. So that's a part of it. Number 2, what defense could he use?
Miss?
Yes, go ahead.
He could use the diminished responsibility defense. Do I need to explain it?
Go ahead. I want to
right.
see how you could bring in diminished responsibility.
All right, so I'll explain and give you a case in point.
Yeah, man.
So he could cry diminished responsibility. First, you need the 3 factors. So 1, a mental disability. 2, it must be caused from a disease.
External factor.
External factors, injury. Oh God, abnormality of the mind, etc. And he must be able to say that or prove that that mental illness was the cause that led him to do the crime. Case in point, R versus Brian, where he was a sexual psychopath and he mutilated and strangled a woman to death. Even though the trial judge overlooked him, he was carried to the Court of Appeal, where he was given the diminished responsibility and his sentence was lessened. So he could use that one.
All right. Okay. So yes, he could use diminished responsibility, but
provocation.
But hold on. I like how you guys jumping up with the defenses. And if you notice, yeah, I saw defenses as one of the topic. Why couldn't he use diminished responsibility? Did your teacher, well, I'm sure your teachers would have highlighted and said to you, look at the facts that you have been given. Do not infer.
Yes, Miss. So the facts did not state that he had a mental.
Right. So you couldn't use diminished responsibility. Do we see that, guys?
Yes, Miss.
Right. So somebody said provocation. Go ahead with that. What about provocation?
Miss, oh, no. Go ahead.
Go ahead,
what
honey.
I remember, well, because in the scenario where they said that one evening that she constantly nags him. That's provocation.
Right? Can we explain it more?
His response was immediate to her action.
Right?
Yes,
anyone else?
Reacted on sudden impulsive, so a reasonable person to lose self-control.
Right?
Yes, so he could use provocation also, to be honest.
Right.
Where he would say because of the constant nagging, it led him to lose his cool, so there was no time to think about what he was doing. Case he could use to support this was R versus Aluela, where her husband but that case was used for the mission. Anyway, but or R versus Thornton rather, where her husband
Thornton, yes.
Her husband normally calls her names and threatened to kill her. And so she went for the button, couldn't find one, then she used a knife to kill him.
Right.
So the provocation would be that the constant nagging which would lead him, to lose his cool for a while. So there must be no space to think about what you're doing.
No cooling off period, right? So we would first say, yeah, he could use provocation. What is provocation? Provocation is things said or things done, words said, which causes someone to lose a sudden or loss of self-control, rendering him not the master of his own mind. So do we see the words coming out? Things said, things done, words said, which renders the individual to lose sudden, and it must be sudden. There must be a sudden loss, a sudden and temporary loss of self-control, which renders him not the master of his own mind, and a reasonable man would have acted the way that he did. Once you have that definition, you pluck it out now, you bring it apart. So you can highlight multiple cases. You can highlight Doughty, you can highlight Thornton, you can highlight Duffy, you can highlight Phillips. Now, of course, as you go to the different, if you're going to break down the elements now, you would use your different cases for the different elements. But if you highlight any of those, you would realize all you need to do now is apply your facts to your case. So John was provoked by Tina with what she was saying. So she was nagging him at that moment. She usually do it. But on that evening, that particular point in time, she nagged him to the point that he lost sudden and temporary self-control, which rendered him not the master of his own mind. And so he began to beat her because of that what she was saying. And so that beating caused him to kill her. Would the reasonable man react the way he did? Possibly yes, based on the nagging. So if you highlight all of those things and then connect the dots and conclude, then you would have gotten your 15 marks. All right? Do we see that, guys?
For the question, how long would you say we would have to write it for? Like 2 paragraphs, 3 paragraphs, a paragraph?
All right, do not worry about the paragraphs. I tell my students, do not worry about paragraphs. You can use a paragraph and answer your questions as long as you have the right things in it. So as I've always said, just go ahead with your IRAC. Highlight the issue first. Then you list the rules. And when I say list, I don't just mean you list the case. List the rule and the principle behind the rule. You understand? So if you're looking at provocation, you're saying words said, things done, which causes the defendant to lose sudden and temporary loss of self-control, which renders him not the master of his own mind, and for him to react the way a reasonable man would have done the same. You understand? So when you list those principles, you highlight the cases that come along with it, and then you apply the facts that you are given to those rules, and then you conclude. That can be even 2 paragraphs. That can be a paragraph. So I always say, don't think about the paragraphs or worry about how much you have to write in order to, apart from your essay, make sure you write enough with information that makes sense to give you a 25 marks. All right?
Yes, ma'am.
All right. So that oops. Any questions before I go?
Is this the only law unit 1 class you will have?
Orin, do I respond how I would want to?
We will get back to you. We are
I didn't
strapped
hear
for
that,
time.
Orin.
We're strapped for time, but if we are able to, we will host another Law Unit 1.
Okay, thanks. And if so, can we please go through some multiple choice questions?
Well, if we have another session, most definitely. I'm not sure if the student council is gonna hit me. I don't know if Orin is gonna give me the okay to say something, but sure, as long as they are able to.
She also does private sessions, guys. So you can book her. $1,500 per session. Reasonable cost.
I am also having a marathon. I'm sure you guys are on social media. Can I, Orin?
Of course, miss, of course.
All right. So my page owns interactive tutorial. I'm on Instagram. I'm also on Facebook. To have WhatsApp, but you guys can reach out to me on those pages, Brown's Interactive Tutorial. We have a marathon coming up, both units 1 and 2, 2 days. And for each day, it's just $2,000 with past paper questions, as well as the topics that CXC would have sent out and how to answer the questions and stuff like that. So it's Brown's Interactive Tutorial. I'm on Facebook, on Instagram. Let me type it in the chat for you guys. Right, so that's on IG as well as Facebook. You can reach out to me. The poster is there. Orain, also you guys can reach out to Orain and the other exec members, if anything. And we have the marathon coming up. Of course, we also have our one-on-one classes, 1,500 per session. A session is so yeah. But Orain, if you guys have more time, I wouldn't have a problem coming back to do a past paper multiple choice with them as well. I don't have a problem with that, okay?
Okay, miss.
All right, any other question, guys?
How do you identify whether a question, how do you identify whether you can use IRAC rule or it's an essay question?
All right, if it's an essay, you don't use IRAC. The essay would be, for example, and they quote a Fiaggio, and then they say, explain what does he mean by the rule of law or separation of power. That would be an essay. So all you'll do is you have your introductory paragraph, your body, and your conclusion. So you just speak, give your definitions of your terms, use your cases. You can possibly give examples, little scenarios, all of that. That would be an essay. A fact pattern is where you get a set of facts and you're asked to advise the persons.
Okay, thank you.
You're most welcome.
Guys, before you leave, please state the name of your school and country in the chat, please. Thank you.
Also, if there are no more questions, I'd just like to take the time to say thank you to Miss Brown or Mrs. Brown, I'm not sure, for coming
Miss
and
Brown.
sharing with the students. Okay, Miss Brown, thank you so much for coming and sharing with the students. We really, really appreciate the time that you've taken to do this. We look forward to further dialogue to see if we can set up another session, seeing that the students do want another session. And students, just to ensure that you don't miss out next time, you can follow us on social media at NSSC_JA on Instagram and Twitter, where we'll be sharing all the information needed.
Alrighty. All right, so if there are no more questions, I will leave you guys. Sure, you can reach out to me via pages. And thank you guys for having me. It was my pleasure to be here. I love giving back, and I love when the student council body of the schools, you know, partake in such activities. It shows that you guys are working. All right. So a big congratulations to the body, and I will see you guys again. All right. So I'm gonna leave now, Aurelie. Thank you, honey. You're welcome. And we can talk, Aurelie.
Definitely, miss. Thank you.
All right. Bye-bye.